Good day, my name is Maurice Arcadier. I'm a partner in the law firm of Allen Arcadier, PA, located in Central Florida. In its basic sense, employment law is a relationship between the employer and the employee. There are very few laws that actually protect employees. Most states have what is called employment at will. There are a few exceptions to this doctrine, and that exception deals with the rights afforded to employees. And this is what employment law attorneys do, either from the plaintiff side or from the defendant side. Today's topic is going to be the Family Medical Leave Act, established in 1993 through congressional legislation. The Family Medical Leave Act, otherwise known as the FMLA, gives employees certain rights. What the FMLA provides is for the employee to take up to 12 weeks off, but the employer does not have to pay the employee's salary. All the employer has to do is guarantee the employee's job when the employer returns from the leave. If the employee must take more than 12 weeks, then he's no longer covered and the employer can terminate the employee at that time. Now, not all employees are covered by the FMLA. The employee must work for a large employer, and the law defines a large employer, any employer with 50 or more employees within a 75-mile radius. Additionally, for an employee to be covered, it must be based on a significant medical condition, either for himself, his spouse, or his children. A significant medical condition is defined as anything that takes you out from work or necessitates you to leave from work for more than 3 days under doctor's care. And the employee should notify the employer as soon as possible. Unless it's a medical emergency, the law requires that the employee, if he knows that he's going to be out 30 days in advance, to notify the employer 30 days in advance. Let me give you an example of an FMLA situation. Let's say that you're working for an employer with 50 or more employees in one location. And let's also assume that there's a medical emergency or a medical situation of an immediate family member, such as your child. As soon as you know of the medical condition of your child, you should inform your employer what the medical condition is. The employer is entitled to know what the medical condition is, and the employer can dispute it if the employer feels that it's not legitimate. Upon informing your employer that you need to take FMLA leave, the employer should provide you paperwork. If he doesn't, you simply need to inform your employer in writing the fact that you're going to take FMLA leave. At that point in time, during the duration, you're entitled to be off and your job will be guaranteed so long as you return to work within a 3-month period. If you're unable to return within the 12-week period, it is at the discretion of your boss or your employer what they decide to do. Most large employers do permit employees to take extended leave of unpaid leave after the 12 weeks, but the law does not require it. There are a lot of issues surrounding the FMLA and when an employee is entitled to take leave and for how long. You should discuss any FMLA issue that you have with a qualified attorney who specializes in employment law so they can properly evaluate what your rights are under the Act.